So once again, I'm so glad you all are here. I just really wanted to thank you and encourage you to throw in your name and also where you're from and into the chat. And then if you have questions and answers, put them in the Q&A, Q&A area, things that you want to share there. And I did want to highlight that, the Ohio Fair Courts Alliance has been slowly growing. And this is one of the webinars that we're doing this year. And, before we go too far, I always think we're going to talk about all of these different problems, but we need to take a moment to really focus on, well, what is it we really want from the courts? What is it we want from a judicial system? We want fairness. We want impartiality. We want a court system that truly works for us. And so as we're thinking about all of the different challenges, we need to be thinking about, well, what is it that we want? What will make for a functional democracy? And where should we go next? And so with that, I just like to highlight, the Ohio Fair Court Alliance, all of our different friends that sponsored this. The way this will work is y'all have been welcomed. And so, yes, Kelly, move us to the next slide. You've all been welcomed. The way this will work is I'm going to first introduce the moderator, and then she will introduce you to the panelists. The panelists will give some remarks. They'll talk about, what they've been thinking about what they've been working on, what the challenges are that they see. And then we'll have a discussion. And I'm going to encourage you all, throw your questions into the question and answer area. And we're not going to get to all of them, but we'll get to as many as we can. I wanted to highlight that the slides, a recording, and then links to additional information will be shared tomorrow so that you don't have to take rapid notes. We'll make sure that you get exactly what you need. And with that, I would like to introduce you to the moderator, who is Maria Bruno. Now, this is our friend from Equality Ohio. She is the policy director, and she has really helped the Ohio Fair Courts Alliance become the Ohio Fair Courts Alliance. She helped us think about, our speakers bureau, think about the direction that we want to go, and helped us really think about where it is that we want to go. And with that, Maria, I'm actually just going to hand this over.
All right. Thank you so much, Catherine. Thank you for inviting me to join you tonight. I was actually so excited when Catherine asked me because I read the panel and I am a nerd. And so this is a very exciting panel for me. I'm really excited to hear from all of these guests. So I will just share with you the lineup, but then I will actually give the bios before they present so that you all can keep all their amazing accomplishments straight. So we will be joined tonight by Jennifer Ahearn with the Brennan Center, Lisa Graves from True North Research, Sarah Turberville from the Project for Government Oversight, and Alex Aronson from the Court Accountability. First, we're going to start with Jennifer, who has an amazing resume. She is currently the senior counsel for the Brennan Center's Judiciary program, working to ensure that federal courts effectively play a crucial role in their democracy. Prior to joining the Brennan Center, she was policy director at the Citizens for Responsibility and Ethics in Washington. You might know of them as CREW, and was the assistant general counsel to the United States Sentencing Commission. So thank you so much for joining us tonight, Jennifer, and I'll hand it off to you.
Awesome. Thank you, Maria. It's great to be here with you all. And thanks, from the Brennan Center, just a big thank you to our partners in Ohio and the Ohio Fair Courts Alliance. We've worked with you guys on many things, I know, and so I am excited to be one of those people working with you now. So my role here is just to sort of both, I think, set the scene for the great experts that are going to come after, and then also hopefully to give just a little bit of orientation about why we think this topic is important. And I guess I want to start off maybe controversially, perhaps, with a pitch to all of you who are here with us. And I might be preaching to the choir with this pitch, but I want to start with what I think is the most important thing, which is, I think in this particular issue, Supreme Court ethics, people paying attention is really, really important. And sort of the second most important thing is letting other folks know that you're paying attention, particularly the court and members of Congress, and just making it clear that people are paying attention to these issues. I know you all hear that about so many different issues. We all do. And so I want to make the case about why I think that this is particularly true for this issue. I've been working on ethics and accountability issues for several years now, as Maria mentioned, and I just think this is an area where people paying attention and making their concerns known can have a really big impact. In particular, here's my case for why you should keep this on your list of things to pay attention to and care about. One, and I think Catherine started off with this, but I think it's worth all of us keeping in mind initially, Supreme Court is really important. Its decisions and actions have a really major impact on people's lives. And I really try to keep that center in mind because I think it can't really be overstated how critical of a role it plays in our democracy. We might talk later about some reforms and whether in fact the court should continue to play the kind of role that it has played, but in any case, it certainly does. And so that's just really important. And I think folks in Ohio particularly, I'm sure, know this and don't need me to say it, but I think it's worth all of us bearing in mind. So my second pitch is that I think it's important that people show they're paying attention because the way that the Supreme Court exercises its power can be really complicated or hard to follow. It might not be obvious to folks, particularly folks who aren't lawyers, but even folks who are lawyers who don't follow these issues very closely. What is the shadow docket? Why does it matter? What is up with amicus briefs? All of these things can seem very, very abstract. And so those kinds of situations where somebody is exercising a lot of power and they're doing it in a way that is not necessarily clear what they're doing, that's obviously a recipe for just, potentially abusing your power, right? And so that makes it even more of sort of critical for folks to pay attention. And then my last element is just that I think the flip side of the coin here is really important. And that is to say, what we need to do is we need to have a court that upholds all of the values that Catherine was talking about in the beginning. But we need the rule of law is also really important, and legitimate courts enforcing the rule of law is really important. So simply tearing things down because they aren't working doesn't necessarily, I think, leave us in a better place. And so what we need is a wise balance that creates something that's really important, a legitimate court system that supports the rule of law and protects critical rights, but also one that can be held accountable because we're in a democracy. And that's what democracy does. So we need sound structures, and because we're a democracy, we need citizens to be engaged. So that's my pitch to all of you. How did we get here? What is the problem? In a way, I think, where we are now is sort of the most logical place that we could land. You have people in power. You have other people who want to influence those people in power. Not kind of the most natural thing in the world to some degree. But I will say that I think the Supreme Court in particular is in a situation where the normal ways that we have in our system to try to rein in the people who are trying to influence the people in power don't necessarily work for the Supreme Court in the same way that they work for other government officials. And, the Supreme Court justices at the end of the day are themselves nothing more than government officials. And, they are need to be held accountable as such, because in a way they are acting for us and in our name. So, for example, with the Supreme Court, obviously one of the major distinctions between Supreme Court justices and other government officials is that they are appointed for life and do not rotate off the court. And really, it's very difficult to remove them once they're there. That's for a reason, obviously. I talked about judicial independence before, and we know that's important, but also it can lead to a situation where there's isolation, insulation, and puts people in a position perhaps to be more ripe for corruption. So that's one thing. We also don't have elections involved in Supreme Court justices, and so appointments. And so you have a lot of different mechanisms by which corruption risks can sort of come into play. So you can see how we are sort of in a situation where it wouldn't be surprising to find that you see the kind of stories that all of us have seen, from the great reporting at ProPublica and other places about folks potentially abusing that power. I just want to lay out a few, briefly before I turn it over, I just want to lay out a few existing structures that are there to rein in the Supreme Court, because I think it can be easy to sort of throw up your hands and say, well, there's nothing, these people are just doing whatever they want. And that's not entirely true. So I'll just pop through a few and tell you what I think you might need to know about them. It is absolutely true that Supreme Court justices can be impeached by Congress. That's never happened. So we don't have a lot of sense of what it might take to actually get there. But in theory, it can be done. There are also a few criminal statutes that would apply to Supreme Court justices in all likelihood. For example, the bribery statute. So if you could actually find a situation where you proved someone took a bribe or solicited a bribe, that could, in theory, be prosecuted as a crime. The Supreme Court now, as of just maybe a few weeks ago, does also have a code of conduct. We can talk more specifically about that later, about sort of what the potential ups and downs of that are, but it is there. It covers largely things like gifts and how the judges associate with folks outside of the court system and those kinds of things. More to come on that from other folks, I think. There are also indeed financial disclosure requirements that the justices and all other judges are required to file. So there are ways that the public should be able to identify financial conflicts of interest potentially happening for the court. We've seen reporting, I think, recently about a lot of shortcomings in that system. And so I think it's good to bracket that as a thing that exists, but query how effective it is. And then finally, I just want to mention that there is a federal statute that requires justices and all judges to recuse from certain cases if there are conflicts of interest or other things that other biases that should require them to step down from the case. So those legal structures absolutely exist. I think sort of what we have seen from the court recently suggests that probably isn't working the way that we all think it should and would like it to, but that is where we are. Maria, I think that's it.
Thank you. That was very informative. Awesome. Well, we are going to move through all of our folks and let them each say a few words, but then we will go back in for questions. So I promise I'll follow up on some of those, and I took notes, I swear. Next, we're going to have Alex Aronson, who is the Executive Director of the Court Accountability, a nonpartisan initiative committed to restoring the integrity of our broken judiciary. A former chief counsel to current US Senator Sheldon Whitehouse on the Senate Judiciary Committee. There, he worked on judicial ethics, oversight, and dark money issues, and advised on the Supreme Court confirmation hearings of Justices Brett Kavanaugh and Amy Coney Barrett. That makes me very excited for all of the insight he's about to offer. Alex, I will hand it off to you.
Thank you so much, Maria, and to the Ohio Fair Courts Task Force for having me today. It's really a thrill to be with you all today, and I wanted to just first thank all of you on the call for all the incredible work you've been doing in Ohio. It's made a huge difference. People all across the country are seeing it, and it's giving us all a tremendous amount of hope. So we're really grateful for all the hard work that we know went into all of your recent successes. I'm really pleased to join you today to talk a little bit more about the role that dark money and special interests have played in bringing us to this really scary moment in which, a durable 6-3 majority of the Supreme Court is poised to really throw a wrecking ball into American lives. It already has, I think, as we're seeing in headlines week after week. To understand how we came to this point, and I'll associate myself with all of Jen's, I think, really helpful remarks. I think it's important to go back into our history to look at some of the important social progress and economic progress that came out of the courts in the 20th century through the Great Society and through the Warren Court era. Of course, in 1954, the Supreme Court decided Brown versus Board of Education, which brought a revolution to the law, to constitutional interpretation, and provoked a strident and really aggressive backlash known as the massive resistance from mostly white males in the South who really resented the Supreme Court's infringement on their control and on what this kind of watershed decision meant for white male hegemony in the United States. Fast forwarding a couple decades ahead to 1971, after yet more important progress was achieved at the court, particularly by litigating groups like the ACLU and Ralph Nader's Public Citizen. This progress through the courts provoked a really concerted and well-funded backlash that took form first in the shape of a memo written by soon-to-be Justice of the Supreme Court, Lewis Powell. His infamous 1971 Powell memo written to the US Chamber of Commerce and called the Attack on American Free Enterprise really laid out a plan for the American business community to take politics seriously and to take the court seriously as a vector for their agenda. And what happened after the Powell memo was that the business community followed his guidance and invested heavily in these domains. And from there, you started to see the proliferation of new special interest legal groups, like the Pacific Legal Foundation out in California that started to take to the courts to advance these special interest agendas through the law, right? And really, I think a key insight that Powell had, and that really underscored the Powell memo was the recognition that this agenda, this billionaire agenda, was not going to be popular. That it had no purchase in a thriving and vibrant democracy, and that they would need to use the courts, which are kind of anti-democratic in their very structure, to advance this unpopular agenda. And then, fast forwarding ahead 10 years to the early 80s, when Ronald Reagan came in to the presidency with the promise of sweeping deregulation and the creation of, in the early 1980s, of the Federalist Society and another group called the Council for National Policy, which understood the wisdom of Powell's strategy and really believed that they needed to invest in the development of more ideas and resources around this idea. And then, really important around this time was, and through the creation of the Council for National Policy, was the alliance of these anti-regulatory business interests with the religious right. And so I think, if you look at this history, now not so recent, you can sort of see the three really important threads that we are now living with in the form of this 6-3 Supreme Court. That is, white racial resentment around the diversification of the United States, a religious right agenda to install, what I think is fair to characterize as a sort of theocratic agenda to infiltrate civic society and impose religious values on all of the rest of us. And of course, the financial driver of this movement, the deregulatory interests from big corporations and billionaires who wanted not to be taxed and wanted, not to be subjected to government regulations that kept them from polluting and from, achieving other negative externalities that make them very wealthy, but make the rest of us quite miserable. And when Leonard Leo joined the Federalist Society in the 1990s, after it had really taken an important step forward through alliance with the Reagan Department of Justice, which was very much trying to advance this deregulatory agenda, it really professionalized this operation and created a multi-$100-million professional apparatus to influence not only the composition of the courts, but its outcomes. And this took various forms. It took the form of dark money and other money coming into the judicial process, the formation of an inside-outside game wherein the Federalist Society and actors like Leo would work with officials in the White House. They had a judicial umbrella group that met inside and outside the White House with people like Brett Kavanaugh from the White House picking those judges to shape the court's composition. It took the form of real investment at the state level and state Supreme Courts, state attorneys general's offices, and state solicitors generals. The funding of intellectual capital across the academy and in major think tanks, and then the formation of yet more special interest litigating shops that took the ideas that those actors were developing and advanced them as litigating theories to really move the law in the direction that they knew would serve their special interests. And of course, this all came to a terrible head with the circumstances surrounding the death of Justice Scalia at the end of Obama's presidency, and of course the years of the Trump administration, with the fateful decision to deny Merrick Garland his rightful opportunity to have a hearing about his nomination to the Supreme Court at the end of Obama's presidency, the cover-up of sexual assault allegations of Brett Kavanaugh, which I'd be happy to get into as somebody that worked very closely on that case. And of course, the reversal of the so-called principle, the so-called Garland principle to install Amy Coney Barrett on the court only 8 days before the 2020 election. So all of that came together in combination, of course, with packing the lower courts with hundreds of judges and investing heavily in the, in putting allies on lower state courts. With this really ugly and very, I think, dispiriting legal reality that we face in the form of a court that has over and over demonstrated its lack of commitment to any type of principle around jurisprudential commitments to concepts they tell us about, like originalism or textualism, and rather, when the stakes are highest, is a reliable vote to advance these very special interests. Of course, we see this agenda year in and year out. It's on very clear display in this term's docket, which again will have major watershed decisions on the government's ability to keep our government, to keep our air and water safe and to protect Americans from the negative externalities of industry. Of course, a massive tax case in the form of Moore versus United States, which could be a massive windfall for the very billionaires that have been pushing this agenda. And a raft of other voting and election cases. This is a court that is very likely poised to decide the outcome of the next presidential election if it comes down to another Bush v. Gore situation. All of which I think really underscores why Jen's final point was so important, that we keep this issue top of mind. This is a court, as we can view it, that has, through the course of all of this investment and over the course of all this time, in which it has moved the law further and further in its direction, has seized constitutional power. And constitutional power, I think, is important for us to think about as a zero-sum game. When the court seizes constitutional power to do with it what it will, it takes it away from the rest of us. And so I think I wanted to close by kind of landing on what I hope is a hopeful note, which is that, notwithstanding how bleak it looks at the court, we have an opportunity to push our representatives to engage directly in our democracy, to take some of that power back. And only by centering these issues, by focusing on the corruption, by focusing on the ties between the flagrant corruption we see on offer and the special interest agenda that is being jammed down our throats, do we have a chance of standing up to constrain this anti-democratic court. So thanks again for having me. I'm looking forward to questions and hearing from my other panelists.
I'm really glad you ended on a hopeful note, because that was deeply depressing on a lot of different fronts. So thank you very much, Alex. Next up, we are going to be joined by Lisa Graves, who is the founder and executive director of True North Research, a national investigative watchdog group that works with journalists and other researchers to shine a bright light on dark money. Her investigations have been featured in Ava DuVernay's Oscar-nominated documentary, The 13th, and in a PBS documentary narrated by Bill Moyers entitled The United States of Alec, amongst others. Thank you, Lisa.
Oh, thank you so much, Maria, for that introduction. And thank you, Jennifer, for your comments, and Alex. And I want to join in thanking each of you, all 136 of you, for coming in here on a Monday evening in the midst of winter to learn more about the court and what we can do to look at what's going on and what we can do about it. So I'm going to take a page from Alex and share and open with a quote. I'll close with a quote too, but share a quote from one of my favorite historians, Howard Zinn, who wrote, "To be hopeful in bad times is not just foolishly romantic. It is based on the fact that human history is a history not only of cruelty, but also of compassion, sacrifice, courage, and kindness." And he talks about how having that hope gives us the energy to act, at least the possibility of sending our world in a different direction. And then he says, we don't have to wait for some grand utopian future, because the future is an infinite succession of presents, and to live now as we think human beings should live in defiance of all that is bad around us is a marvelous victory. And so one of my hopes in this call and your work in the year ahead is to continue to cultivate that hope in the midst of, some of these really challenging situations that we face. And so I want to begin by talking a bit about, to build on what Alex said about how we got here, which is that the US Supreme Court was targeted by right-wing interest for capture because of the role it plays in American society. And that really has its roots in Brown v. Board, this reaction to the idea, the actual original language of the amendment to the Constitution after the Civil War, that people are entitled to equal protection of the law. It's plain that the Crow regime, the racial segregation and more, was an utter defiance of the command of the Constitution, but the court countenanced that for almost 100 years. And that's not all. The Supreme Court's history, before the history that we all may know or remember, in many ways is riddled with terrible decisions. Like, I just would be remiss if I didn't mention the case of Bradwell versus Illinois, in which the Supreme Court about 120 years ago opined that women just don't have the intellectual capacity to practice law. Obviously, a terrible and ridiculous decision grounded in a complete misunderstanding of both the law and human beings. But that's not all. We can see that fast forward now to the Dobbs decision, where you can see this arrogant Supreme Court, this completely Republican faction of the court, basically trying to rewrite history. And as Politico reported just this past week, doing so in a way that's citing history that is handpicked, cherry-picked, and deeply flawed in order to advance a really regressive agenda. I won't get into more details of that, except for to say that, it's interesting to me when I read the 14th Amendment that not only talks about equal protection of the law, it also says that people born in the United States are entitled to these rights, these privileges of citizenship. So the 14th Amendment itself does not situate rights before birth. But this court has sought to impose its own personal religious beliefs as mandatory binding law on the rest of us. And the next phase of that battle is being fought in the states, as you all know so well, in Ohio, with the efforts this year to try to make it harder to amend the state constitution, and then to change the rules for whether the people of Ohio have the capacity to protect these core rights, the right to choose your destiny. And so these battles are continuing. As you know, the state legislature there in Ohio has made noises that it's going to keep trying to push forward with this extremely regressive, repressive agenda in defiance of the people's voices. But I don't think that you're going to let them prevail in that, quite frankly. But let me get back to the main topic at hand, which is what's been happening with this court. I think, as Jennifer mentioned, the court can seem quite mysterious, and I think it likes that mystery. But in some ways, it's not very mysterious at all, because what's happening is this U.S. Supreme Court, unlike the court in your hometown, which people file cases and the court has to hear them, the Supreme Court doesn't have to hear every case that comes to it. The Supreme Court chooses every case that it hears, but for a very rare case in which one state sues another state. So if you look at the current Supreme Court recent history, it's deciding directly after oral argument about 60 to 70 cases a year. And it is literally hand-picking those cases. One year, they're taking up union rights to try to destroy union rights. Another year, they're taking up environmental issues to try to destroy our capacity to regulate corporations to mitigate climate change. That same year, while they were saying that we did not have the power to regulate corporations to have, to invest more in alternative energy, they were saying, but of course, in essence, the state has the power to regulate whether, when, and how you can choose to have an abortion. And so for human beings, the standards were different than for corporations. Just this past year, the court chose to take up questions of affirmative action and efforts to redress racial discrimination, historical and ongoing racial discrimination. And right now, the court is considering rulings about whether to change our tax code to make it easier for billionaires to continue to keep more and more money out of our public investment in our, in our society, and more. And so this court, this faction that controls the court, it is exercising extraordinary power, and it is issuing rulings that are at odds with long-standing legal precedents, including the reversal of Roe, nearly 50 years of precedent, and more. But Leonard Leo, whom Alex mentioned, as the sort of main money man for the Federal Society, the person who has liaised with a number of these billionaires to advance this extreme and narrow agenda. His agenda, as he articulated to the Council on National Policy, which was one of the groups that Alex named, was basically, he said to that group of funders, of right-wing funders, that no one in the closed-door meeting of the Council on National Policy had seen the kind of revolution, which he called a revival, of what he described as the structural constitution. No one alive in that room had seen it, and that this was basically going to roll back the law a century to before the New Deal, to back to the robber baron era, where corporations really held extraordinary and destructive power in American society, and where people's fundamental human rights, their rights to equality and more, were not enforced. But it's not just those substantive outcomes, it's this culture of corruption that has been allowed to take hold of the court due to the type of judicial lobbying, as Alex has described it, that has been allowed to take place through these amicus briefs, these briefs to the court by groups that are tied to Leonard Leo and some of these billionaires, funded by them in order to create the rationale for these extreme decisions and try to justify them. And it's not just the amicus brief racket that Senator Whitehouse has so compellingly spoken about. It's also this gravy train of gifts and gifts of travel on luxury jets and super yachts to exclusive resorts, statues, paintings, and more, that the billionaires who are friends with Leonard Leo have helped orchestrate to keep Justice Thomas on the court, as the story that just broke this morning in ProPublica describes in detail. That Clarence Thomas was threatening during the Clinton administration to leave the Justice Department, to leave the Supreme Court if he didn't get paid more. He wanted to be able to get speaker fees. Lo and behold, suddenly he starts getting a whole bunch of gifts to keep him basically as a sure vote on the court. And while these billionaires who have been bankrolling this may not have had that many cases themselves before the court in terms of their corporations, their agenda has been before that court over and over, and increasingly so. So before I get to my last quote, let me just conclude on the intersection, an example of the intersection between the culture of corruption and the substantive results. And so Politico reported a couple months ago now that as the Citizens United case was pending in 2009, that case that changed the rules for elections and limited the power of Congress to limit this dark money being infused in our elections, as that case was pending, Leonard Leo, Cleta Mitchell, who you may have heard of in the news, Jenny Thomas, Clarence Thomas's wife, they were working together to create a group basically to exploit the decision to come. And in the midst of that, Harlan Crow, the famous billionaire that collects Nazi memorabilia, actually staked Jenny Thomas with a $500,000 gift for her organization to pay her salary, and she expedited the approval of that corporation on New Year's Eve. No doubt that Thomas knew that this gift had come and that she was moving forward with this organization. And then just days later, Thomas was the fifth vote in a 5-4 decision in Citizens United to basically try to kneecap the ability of Congress to regulate the influence of billionaires on our elections up and down the ticket, from school board, in essence, on up to the Supreme Court, although particularly in the federal regime, but to create that precedent. So that was an inherently corrupt decision. It was a destructive decision, and it's one that requires redress along with substantial reforms, which we'll talk about on the call. And I'm going to conclude with my quote from a pen that I carry with me all the time from one of my true heroes in life. It's from Frederick Douglass. And he said, "Power concedes nothing without demand. It never did, and it never will." And so our job together is to make that demand to power to change this, because it doesn't have to be that way, the way it is, and we can change it. So with that, I'll pass it back to you, Maria.
Thank you, Lisa. That was very informative. All right, last, before we open it up to question and answer section, we have Sarah Turberville, who is the director of the Constitution Project at the Project on Government Oversight. She's an expert on access to justice, fair courts, and the protection of constitutional rights. She's been cited recently by ABC News, Fox News, the Associated Press, and courts, and her writing has appeared in NBC News, The Washington Post, and Just Security. Thanks for joining us, Sarah, and please take it away.
Thanks, Maria. And I just want to associate myself with all the comments of the panelists who have gone before me. And thank all of you for being here tonight, and for Ohio Fair Courts for organizing this. I am going to get into the Supreme Court Code of Misconduct in a couple minutes, but I think what would be helpful and what my role is here is to give y'all a little bit of a state of play, both in Congress and from the court itself, when it comes to dealing with what is, in essence, a corruption crisis at the Supreme Court. I don't want us to overcomplicate the issue. At POGO, we work on exposing corruption and proposing solutions across the federal government. And make no mistake, this is about corruption. It's abuse of power for personal benefit in many and varied ways. And in some cases, as has been mentioned tonight, it looks a whole heck of a lot like a quid pro quo. We've got Thomas and the Chevron doctrine, for example, right? And he was a longtime supporter of Chevron, which is a doctrine that defers regulation of industry to experts and government agencies rather than the courts. And overturning this doctrine has been a major target of industry, and Thomas has reversed his position on it after years of unofficial influence by these benefactors. And then we have what Lisa just mentioned that broke in ProPublica today about him threatening to resign over judicial pay. And then his resolve was sort of stiffened by conservative benefactors and their money. And Thomas upheld his end of the bargain by staying on the court and providing, as Lisa said, a firm vote for the conservative and industrial agenda thereafter. I try to imagine, when I think about simplifying this, the sort of outrage we would see if the shoe was on the other foot. If we could imagine Justice Sotomayor or Kagan taking lavish vacations with billionaire benefactors and entering into real estate deals with them, or if their relatives were engaged in business before the court, surely we would see Republicans clamoring for reform and investigations and impeachment, probably. So I just want to caution us not to be distracted, because the subjects of the investigations that are now underway by the Senate Judiciary Committee most prominently are really trying to distract us from what's actually going on, with lots of spurious arguments about the separation of powers. And to be sure, this is unofficial persuasion, which is really anathema to the rigor of what judicial decision-making is supposed to be about. And this is why the justices' willing acceptance of influence peddling by the billionaires is so troubling. For a sec, I want to focus on how and why this has persisted. I think Jen is right. There are some ostensible guardrails on the court on paper, right? But no accountability in reality. The justices violate the Ethics in Government Act time and time again, and face no civil or criminal penalty. Meanwhile, within the judiciary, the judicial conference is not serving as any sort of oversight mechanism of the court. Instead, it is really serving as a mouthpiece and almost like a lobbying arm for the judiciary and the Supreme Court in particular. And of course, the justices themselves are obviously incapable of self-policing. Indeed, they draft a code of conduct that ends up codifying a lot of their bad behavior. So then we look to Congress. And certainly there are some substantive bills that you all might be interested in that we can talk about that are meant to rein in the corruption and provide an enforcement mechanism. But I want to focus my comments here on the importance of congressional oversight and investigation in this space. The Congress, in pursuing this, is not seeking to punish the court for its decisions, although, as other panelists have pointed out, that corruption certainly affects its decision-making. But a robust investigation of the networks that seek to corrupt decision-making at our Supreme Court is necessary to do what all congressional oversight seeks to do, which is uncover wrongdoing to aid in production of legislation that can prevent similar abuses in the future. This is what oversight power is all about. You can just ask the Supreme Court, which has produced a litany of precedent affirming congressional oversight authority. So on that point, since the spring, since this first ProPublica story broke about Thomas and Harlan Crow, the Senate Judiciary Committee has been investigating, and at first they sought cooperation. In April, they asked the Chief Justice to investigate the undisclosed gifts to Thomas. As far as we know, he declined to do that. Then the Judiciary Committee Chairman, Dick Durbin, invited the Chief Justice to come testify before the committee. The chief declined. Then all Democrats on the committee sent a letter to Harlan Crow seeking voluntary information about gifts and travel given to Thomas. Crow and his response was both invasive and defensive. And then the news broke about the influence of other billionaires, people like Paul Singer and Robin Arkley. And the committee sent similar letters to them, as well as to Leonard Leo in July and then again in September. And the committee was largely in receipt of some incredibly disingenuous and far-flung arguments that these billionaires and Leo couldn't even be subject to congressional oversight because they're really special people. So then after that, the committee's hand was forced. And after Thanksgiving, they voted to authorize subpoenas for Harlan Crow and Leonard Leo. To be sure, there was vigorous opposition from the right. After all, Leonard Leo is not just the sugar daddy of the right-wing justices, but of the entire, ultra-conservative legal movement. So they had a lot of skin in the game, and they fought desperately. There's also some other investigations underway. In fact, it was the Senate Finance Committee that successfully investigated a loan by a man named Anthony Welters, who was another wealthy businessman that Thomas was associated with, who forgave Thomas's loan for purchase of this luxury RV or bus, which has some tax implications for the justice. And then there are certainly more avenues that need to be pursued. For example, the utter ineffectiveness of the judicial conference in ferreting out misconduct, while we continue to support and push the Senate Judiciary Committee forward on its investigation of the gifts and largesse that has been bestowed on a handful of justices at the court. So in the midst of all of this, in fact, right before the subpoenas were to issue in November, the court surprised many by issuing its own code of conduct. And, our view, and I think this is a view that is shared by many that have been working and asking the court to issue a code of conduct for some time, is that this might be worse than what the status quo was. In several respects, the code that the court issued seeks to legitimize the corruption that has permeated the justices' conduct over the last couple decades. There are a few slides here to assist, but I wanted to distill the problems with the code in plain English, so that's sort of why I went to PowerPoint here. But I think there are two main takeaways, and this first slide illustrates one of them. And that's the first, is that they just don't get it. This is the introduction to the code of conduct that the court issued in November. And its disdain of the public scrutiny of its own behavior is pretty apparent, which is just, it's just absurd. Essentially, it's stating that the problem is not, let me restate this a different way. The problem is not that people don't understand all that the court does to uphold ethics, right? The problem is that for many years, the justices have acted in ways that actively undermine the public's confidence in them. If you could go to the next slide. And the second main takeaway that I'd like to share with you is that it really looks like they've taken the low road and have carved out for themselves a litany of activities that are permissible and should not be, and then they've left some problems completely unaddressed. So just to quickly go through what that looks like. The current code now, allows the justices to continue to be judges in their own cases when it comes to disqualification. It continues to allow them to do book deals and to allow taxpayer money to promote them, to use taxpayer money to promote them. It puts the desire to have 9 on a case above any sort of conflicts of interest. It's so if there was in a case where it clearly, under ordinary circumstances, a judge should disqualify themselves, the court has now said on paper, no, it's more important that we have 9. If you could go to the next slide. It also continues to allow gifts, ostensibly as long as they're reported. But so the largesse can continue to flow. It doesn't require the justices to explain why they didn't disqualify themselves from a case. It continues to allow fundraising by the justices and or they're using their name and likeness in support of that. It continues to allow engagement with highly partisan and ideological organizations, publicly and privately, continues to allow spouses to hide their sources of income, and of course, it proposes no enforcement mechanism whatsoever. In our view, this is the code that they issued is simply a colossal missed opportunity. And you can see that if you can imagine for a moment, like the path that was not taken here. And that's the path where the justices recognize that they are some of the most powerful people in the country. They are people who have their jobs for life. And thus they have created rules that would go the extra mile to ensure their conduct is beyond reproach. You know, instead they came up with a code that holds the highest court in the land to the lowest standards. So all that said, I too will try to end on a high note, and it has to do with the code. And that's the fact that the idea that the court issued this is certainly an example of the fact that the pressure is working. This is an institution that has operated since the dawn of the Republic without a governing code of ethics. And the pressure of the last several months, the investigations, the research, the advocacy, the civic engagement, has pushed it to do something that it has not done in 200 years. So I will just close and say that we have to keep pushing.
All right, thank you so much. Let's discuss. That's right. Okay. So I am going to jump right in because I know I have a million questions, and I'm sure there's some audience questions as well. But so Jennifer, you talked about the limited examples of the past of examples of actual violations of these ethics codes. So tell us about if that has actually worked in the past, either with SCOTUS, or I will even accept, does it work at the lower level, but just not for SCOTUS? I would also be curious about that example. And I guess also I'm going to add in just to really give you a 1-2 punch here. Given that their new code seems to allow everything, how does that play in too? Does it weaken the protections that we sort of already had through general ethics standards?
So, this is two good questions. So I'll start with the second question first, and that annoying thing that people always do when you ask them 2 questions. But I will say that I do think that there is a significant risk. Obviously, this code of conduct was just issued, so I'm not sure we know yet what the downstream impacts will be. But I do think that when you look at how, for example, when you look at how lower court federal judges responded to some of the scandals, the reporting on Supreme Court ethics scandals, you saw New York Times op-eds from lower court federal judges saying, like, this is obviously, these people know this does not smell good. Like, these people are like, I would never be able to get away with this, so like the lower court judges, they know that this stuff is totally outside of the bounds of what they would be able to get away with. And so, I think it is quite likely to sort of have a situation where you will see those folks looking at the people above them on the food chain and saying, well, why am I going to sort of comply with the rules or color within the lines if, these guys aren't doing it. So I think you're right to sort of raise that question. And I think it is quite likely that we will see some of that in the future, although it might be hard to know. As far as how things actually work in the lower courts, I think the way that we have seen these things work out in the lower courts, and I think in the federal courts in general, you could say, like, it's still not great, but you do have a situation where a lot of judges in those lower courts do have judges who are above them on the food chain, who can actually sort of who can step in and can tell those judges, yes, you must recuse in this kind of case or not recuse in this other kind of case. And so there is a system within the lower courts where those complaints can be taken to those judges, and there is a way to do it. Whereas with the Supreme Court, what you have right now, I mean, Sarah made this point excellently with her all caps. I think there is no enforcement mechanism for the Supreme Court. And I think that is the thing that is sort of the main problem here, is that the justices are truly policing themselves. I don't mean the Supreme Court writ large is policing itself, or I mean the individual justices are policing themselves. And you don't see that really in the lower federal courts. So even though that system may not work as well as we would all like it to, it is a system that exists and does occasionally work. And of course, in the Supreme Court, we don't have any of that.
So, Alex, I'm going to follow up with you, sort of potentially in the gap where perhaps we wish enforceable ethics standards were. We have transparency trying to fill some of those gaps. So, how does transparency help? How is knowing about this, how does that contribute to the solution?
Thank you, Maria. That's a really great question. Transparency is essential, right? And we don't have good enough transparency now in either existing federal law or within the judicial codes. And it's that lack of transparency that has kept us in the dark for all these years about what's really happening there. And we're only starting to get a taste of what transparency looks like in the form of intrepid independent research like Lisa has been driving, and in the form of this new wave of investigative journalistic scrutiny on the court. This is a court that has for decades been sort of treated with kids' gloves by the political press and by politicians. I think we've all sort of bought into the idea that they are above the fray when it comes to politics. And the transparency that has been provided by this essential reporting shows us that's the farthest thing from the case. I think the importance of transparency and the potential for change that it gives us, we can see in the seeds of the political movement that is arising in the wake of these disclosures. And it underscores the importance of the congressional oversight that Sarah was focused on. And I think, it's been a long road by many of us kind of in the accountability and advocacy community to get the Senate Judiciary Committee to the point where it is now, where it has now issued these subpoenas. I think the Democratic Party and the old established leaders of the party are really reluctant to wade into these thorny politics, right? They're going to get attacked for, attacking judicial independence or whatnot. And I think they really are worried about that. But what we need them to understand is that, judicial independence is compromised. It's not their oversight that will have anything to do with whether judicial independence is compromised. The court has been corrupted. It's been captured and infiltrated by these special interest donors. And if the Congress doesn't do anything about it, then nobody will be in a position to. And so that's why, really putting pressure on these members to help them see not only the political opportunity of this, persistent oversight, much in the way that January 6th and the sweeping narrative story told by that committee really was beneficial to their political careers, but also the necessity in providing this accountability and this transparency to the democratic process itself.
No one likes hearing it's going to be up to Congress to fix it, but I suppose in this instance, that's the truth. So Sarah, given that, what would reform possibly look like? And I guess maybe two categories. The first is the dream list. If, all politics cooperated, what kind of reforms could be in place? But then the second is, what can we actually get through given the politics that we have today?
I think there's a second piece to that too, along the lines of what Alex was suggesting, which is it is on the oversight and investigation part of this, it is so important for members of Congress to know and to hear from people that they care about this, right? I mean, from our view, it is like politically, it's a winner, right? Like to be able to talk about this because the other side is just associating itself with corruption. But on the sort of substantive front, with respect to ethics specifically, I think, one thing that is obvious to, I would say to probably all of the panelists here, is that there really need to be conduct limits on the court. And, it shouldn't be okay for Justice Thomas to go on a, $600,000 yacht voyage or whatever in Indonesia, as long as he reports it, right? Like that kind of conduct should be prohibited. And instead the justices are allowed to do things that would, get a low-level executive branch employee investigated by the Department of Justice, So like, so I think we need gift limits. We need a gift ban, essentially. We need stiffer recusal standards that, I think we need to really challenge this notion that it's more important for all 9 of them to be sitting than for there to be disqualification because of a conflict of interest. So that's important. I think we need explanations for why the justices have or have not recused from a case, because that would help create kind of like a body of precedent in a way that would assist other judges as well in making those kinds of determinations. I think we need an inspector general for the judiciary. And that is the thing that maybe is not, that might be one of the more practical pieces here. I mean, that's something that Senator Grassley has supported for a long time. And I think a lot of people, myself included for a while, were a bit squirrely about it because of fear that it might be sort of politicized and used to sort of hem in the court's independence. But that hasn't been the case with the way that IGs have worked in other federal agencies, for example. And I think everything that has been uncovered over the last few months makes clear that there needs to be an independent entity there to ferret out waste, fraud, and abuse.
And Lisa, I'm going to have you bring us home literally here. Connect us back to Ohio. Why should Ohioans in particular care about this? And, what can we do to put a dent in some of this?
Well, I think, Ohio is already doing a lot to help respond. And so you just got to keep doing that and more of the same, quite frankly. Ohio is on the front lines of the battle to protect access to abortion care. Ohio is on the front lines of the effort to actually have maps that are reflective of voters versus maps that are these grossly distorted, Frankensteins that basically allow these supermajorities of right wingers to step all over people's rights, and in defiance of your own Ohio Supreme Court. To allow these politicians to act without any consequence. So, and voting rights in Ohio. Ohio is a long-standing battleground, no matter what the sort of most recent, presidential election results have been. It is a state that has a substantial number of progressives living in it, people and centrists, people who care about the rule of law. These issues about our courts and having fair courts, genuinely fair courts, like the Ohio Fair Courts Alliance pushes for at the state level, and nationally, fair courts are vital to justice. They're vital to our democracy. They're vital to the integrity of our system. And so these issues are fundamentally, in my view, moral issues. And when you have moral issues, you don't give up just because you didn't win everything you wanted in the most recent legislative cycle or the most recent election cycle. You stay on that fight until that moral issue, that moral question is answered, vindicated, to protect people's rights in our democracy. And so there are some specific things, and we've had a bit of a list of those for you, but definitely would ask you all to circulate these stories that you're hearing about, because the polling shows, not that polling dictates everything, it certainly doesn't, but the polling ratifies that these issues are offensive to people across the board, regardless of political party, not to the same degree, but that's because most people actually do want fair courts. They don't want courts with their thumb on the scale of justice. They don't want courts where the decision is preordained because some rich guy and his rich friends got together and decided who gets to be a judge in order to destroy your rights. That's not normal, and it's not okay. And so, there are calls you can make to your members of Congress, regardless of their party, to your senators. You can back up senators who stand behind these reforms and urge further investigation. You can call on the Senate Judiciary Committee and the Finance Committee of the Senate to deepen their investigation. You can call on Clarence Thomas to resign. If he had any integrity, he would, but he doesn't, so he won't. You can demand a better House that can actually hold him accountable, because the reality is that even though no U.S. Supreme Court justice has ever been impeached, the most often impeached officer in the entire federal system are federal judges, lower court federal judges. So there is precedent if we only have a majority willing to investigate and fully examine what's been going on in the court to corrupt it. And then the last thing is, this court is going to continue to issue damaging decisions, terrible decisions that seek to destroy our rights. Those decisions are inherently illegitimate because the way this court was constituted, the way those seats were stolen. But for the theft of those seats, this would be a 5-4 court with a majority of Democratic appointees in the driver's seat in that court, honoring legal precedents versus destroying them. So we cannot let those decisions be the end of the conversation. They're the beginning of the conversation. And that's a conversation that we can win if we continue having it with our friends and colleagues and family about why fair courts matter, why our rights that are at stake, and why these courts that are out of control need to be checked by the power of the people. So I guess I'll wrap there. And thank you so much for having me or giving me the last word.
Absolutely.
Well, and on that, I just want to say a big thank you. A big thank you. Here are a couple things that we'll be sending you so that as we've suggested all the different ways to get engaged, I did want to highlight, that this all came together because of Jessica Dickinson, who is the Ohio Fair Courts Alliance outreach and engagement manager. I have to say a great big thank you to all of the panelists. I just really appreciate, having the time that you all put in. And I just wanted to say a big thank you to our moderator, Maria Bruno. Now, Maria, do you have a few words you want to say to bid us adieu?
Oh no, we ended it so well. I don't think that I can top that. No, I appreciate this so much. Our organization has been on the front lines of some of the most extreme legislative attacks to some of our community members here in the state. And I think that courts are a really, really important stopgap during uncertain political times. And this is a really important conversation. So I really appreciate you all taking the time. And for the 100 and some folks who came and watched, we appreciate you all keeping the attention here as well.
And a big thank you again. We can't tell you how much we appreciate your making time to have this deep conversation. And happy holidays to everybody. And happy New Year 2024. Here we come. And you'll get follow-up tomorrow. Big thank you, everybody.
Thank you so much, everyone. Have a good night.
Be well. Happy New Year.